Hey, this is Kristen Ishihara and Chris Parker. We're attorneys with the firm of Ishihara and Parker here in Longview, Texas. And this morning, we wanted to talk to you about what is a revocable family living trust. A lot of times we have clients that have heard of that or know people that have trust, or their parents had trust, or maybe their neighbor's house is in a trust, and they just kind of wondered, what is this tool? Could I benefit from it? So we just want to talk about what it is and who might benefit from it. So we'll start there. Chris, why don't you tell us just kind of in general, what is and so today I do want to talk though specifically about a revocable family living trust. There are lots of different types of trusts, but today we're going to focus on that, so our comments will only really apply to that, what we would call an RLT, or a revocable family living trust.
Sure. So a lot of times people come in, they're pretty familiar with a will. We've talked about wills in the past. You write out your instructions. All you have to do is pass away. Right, very easy on the person who's creating it. But then the most important or most common alternative we see is a revocable family trust. Family member comes in and they want to learn more. Say, okay, basically what we are doing is creating a document that has several different roles, right? You got the grantor of the trust, that's the person creating it or funding it. You got the trustee of the trust, that's the person running it. It might be the same person, might be someone different. And then you got the beneficiaries of the trust. Those are kind of some of the roles that are involved in a trust. When you're setting these roles up, you are determining who's in charge, to what percentage they're in charge. Like, what are my powers of a trustee? Are they broad and expansive? Well, in this type of trust, yes, we're dealing with trust that you are controlling your assets while you are living, yet you are also controlling how they pass when you are deceased. It's more involved than a will, right? You're doing more steps. You are taking steps now to create this tool that'll help estate planning moving forward. It's one of our favorite tools. It has a lot of advantages and a few things to consider. What are some of our favorite advantages?
Well, I think we should talk first about just who the average client is. So who are we talking about this tool with? Would be, say, a couple that comes in that's looking at retirement and they're ready to put their estate plan in place. Chris and I would talk with that client about what their options are. Their options include everybody should have that will, powers of attorney, and directive. So that's at a minimum what you need. As a potential, I don't want to say next step maybe, but a little bit more sophisticated is the Revocable Family Living Trust, where you do the work now. You basically set up your estate during lifetime. So, from our perspective, we really don't want to push people in either direction. We don't necessarily feel like one is better tool than other. We're going to put the same estate plan that you tell us in your will, and that will gets probated when you pass away, or in your trust, and then if done correctly, the trust does not get probated at your death. So it's really just a personal preference, I would say. We just want you to have the information so that you can make that decision yourselves. I would also say a lot of times people are curious about the cost. They're about the same for us. It's just different times when you pay. So if you do a will first, your cost is lower, but then when your kids probate it, they catch up and they pay what you would have paid in total for the trust. So trust is more cost up front, more work for you. So when people choose it, I think they're usually thinking, I'm okay with that.
Right.
Yeah.
Making it easier.
Right. That is a big benefit, I think, when people choose the trust, that they're trying to make it easier. But yeah, so some of the common benefits we see with a trust, or why people elect to use it, I think one of those is privacy. Do you want to talk about the benefits there?
Yeah, absolutely. So remember, we're comparing a revocable family trust to a will. When you are going through the will process and you are the executor, you're required to create an inventory. Well, an inventory is a list of assets. It's public record. It goes to the courthouse. People will see it. Not that that matters for most people, but to some people, it certainly does. There's some people with professions that rather keep it private. There's some families that rather not have their business shared with whoever happens to look. A revocable family trust is very good at keeping it private, because upon your death, your assets will pass outside or independently of the court process. There is no inventory being filed down at the courthouse. There's no public filing. So privacy is one of the biggest reasons that people, will ask for one. They'll say, well, is it secret? And I'm like, well, it's private. I mean, government knows what's going on. There's not like, but your family members will be able to receive their properties without going through the court process.
Privacy as to the assets that you own are not now made public record at your death. Plus, I think one other neat benefit is depending upon how you're disposing of property. Let's say my husband and I have 3 children, but our oldest daughter is estranged and we do not want to include her. If in the trust we say that we are leaving everything to just our 2 children and not our oldest daughter, when we pass away, only the beneficiaries of a trust are entitled to get a copy of the trust or know anything that's in the trust. So our estranged daughter really has no access to even see what our trust says. Yep. She doesn't know what the assets are in there. It's kind of a negative example, but it can apply in a lot of different ways. If we had done that as a will, our will would have to be probated, where my will would say I'm disinheriting said daughter, so that would be of public record, and then my assets would again be listed on an inventory. So when you think about privacy, it's both as to assets as well as to beneficiaries. I think there's benefits there.
Absolutely. I mean, it's harder for someone to make a ruckus, if you would, to cause trouble if they're not even sure really what you own or how it's going. Sometimes you're just making it easier for the folks that you want to inherit and excluding those people who do not need to be part of the process. Absolutely.
Right, yeah. So one benefit would be privacy as to both assets and beneficiaries. And then 2, I think, is also just the potential for conflict. So, we kind of touched on that with the privacy aspect. But, what if I am anticipating one of my children to be a pain?
Yeah.
Is that a good option?
Yeah. Oh, yeah, absolutely. If you know, I mean, I've had it before. I've seen situations where, like you said, someone's cut out or there's an unequal distribution or things like that. A trust just adds a level of planning that makes a sour beneficiary or an excluded member of the family have a higher or harder burden to cause trouble.
Right. Yeah. So if I have, let's say I am leaving then 75% to oldest child, 25% to youngest child. If I do that through a will, my oldest child is presumably my executor. They have to go probate that will. Well, if I'm including that smaller percentage child in the will, now they're a beneficiary. My executor child getting more is going to have to provide certified mail notice to that beneficiary, is going to have to work with them to make that distribution. And then there is a open probate proceeding, very easy for 25% child to hire a lawyer and come contest the will. It's already set up for them. It's there for them to do. With a revocable living trust, same percentages, same fact situation. There is no probate case, though, so there's no open court proceeding. If 25% child who still gets notice, right, they're still a beneficiary, they're still involved, they receive their 25%. If they want to do something about it, they have to hire a lawyer, come out of pocket, and pay to sue the trustee to dissolve the trust as it was set up. It's much harder, and I would say it puts a much greater burden on that child and gives them some incentive to just take their 25% and be happy with it.
Why bother with it if you're uncertain outcome? Much more ringable, much more things hoops to jump through before they can challenge a trust.
Right, and that's kind of just investigating a little bit what attorneys take. So if you're looking at a will contest, if that individual is upset, there are some lawyers that you can pay out of pocket to contest it, but there are also personal injury lawyers who will take that on the contingency based on how big your estate is because they can see it in your inventory. So you've just given that child more tools to fight against your other child.
Yep.
Yeah. Yep. So number 1, privacy. Number 2, if you have potential for contest or maybe, different distributions to kids. And then, we're talking about it, around it, but just avoiding probate in and of itself is a benefit that people choose. You want to talk about that?
Yeah, I mean, here in East Texas, we do have great courts and we have great judges, but they have thousands of cases, right? And I'd say most of them go just fine. Every once in a while, everyone's unfortunately there and not happy. But you can avoid that. You can avoid the government interaction. You can avoid going to court. You can avoid the notices. You can avoid the postings. You can avoid testifying. You can avoid making the inventory, maybe the bond. There's all these steps that you can remove from the process by doing a revocable trust for your family. Definitely a more streamlined process when we start dealing with trust. Yeah. So long as it's funded, it'll be a much more streamlined process.
Yeah, absolutely. And a lot of times that's related to the sale of the house, right? So, you pass away, your kids are out of town, so they're coming in to try and deal with setting up your funeral and other things. Well, while they're here, they're going to start working on personal property in your house. But it is actually, going to be time intensive for them to deal with just the practical aspect of you dying. Your mail, your personal property, your food in the fridge, your car. Like, that's a lot of hands-on work that they're going to deal with. So when you add probate to that, Now they're kind of stuck waiting for the will to get probated, them to get appointed as executor, then they can engage someone to do an estate sale, then they can engage a realtor, then, you know, so the trust skips that. So I had, he was a single individual, but he'd put everything into an RLT for his son who lived out of country. It honestly helped a lot that he had done that. When he passed away, son traveled in, handled final, stuff for dad, but was able to list the house immediately, didn't have any hangups with the sale. It had just set it up for him to be very, very easy. And I know I've given this example in the past, but I would say in Gregg County here where we are, you can do a probate in under 30 days. We're very blessed. It doesn't have to stay like that. I did one in Dallas earlier this year, and it took me 12 months. So in addition to having estate checks that you can't cash that are now over the 90 days and have to go back, you're hanging on to all the estate assets that you cannot deal with. We're lucky here in East Texas to have courts that will get a probate through faster, but that could always change based on, COVID, court reporters, other things. It is something to consider, the timing that you're putting in there.
If your beneficiaries are folks who are unable to handle tragedy, right? I've had that before where they know the spouse will say, listen, when he passes away, I'm going to be a wreck. I'm going to shut down. I'm not going to be able to do the steps necessary. Or if your children are unable to process your death. Look, everyone goes through grief. That's common. But there are some people that it hits them harder than I'd say the average person. If that's a situation, then maybe you should also look at a trust based on the emotional fortitude, if you would, of your family.
Yeah, absolutely. Good point. And I think that segues us into the next one, which is considering management in the event of your incapacity. So let's say that we have a couple, husband is primary caregiver, paying the bills, wife now has a diagnosis of dementia. Sometimes, I would say actually quite often in this scenario, we utilize a trust to plan for the event of the husband passing. So let's just assume they have enough assets to pay for her care. Husband is terrified if he passes away as the caregiver who pays all the bills, who's going to be able to do that? Right. So considering not just death transition, but also planning for incapacity, this can be a really powerful tool. If you've set up the trust, funded all your assets in there, and said, if I die, this child or this corporate fiduciary is going to step in and serve as trustee to make sure that my spouse gets provided for. I mean, the relief that can provide to somebody who is just, very concerned about that, doing caregiving every day, that's a really good option. Just
to make sure everyone understands. So when we have an incapacitated spouse we're worried about, you're hoping they've already have or can do their powers of attorney so that the family members, husband first in this scenario, and then maybe adult child, can handle their non-trust assets. Then you have the trust itself, presuming people can sign. They're able to fund the trust, and the husband says, hey, I'm the trustee. I'm helping take care of my wife, who is a co-creator of the trust, but not a trustee because of what's going on with her mental condition.
Grantor and beneficiary, but not a trustee.
And then I name my child or children in order to serve, so that they're able to manage the house, take care of the checking account, the things that are owned by the trust for the benefit of their mom.
Yeah.
That way, if you are able, not always works out, but if you're able to, you may be able to avoid a guardianship, which is a real blessing.
Absolutely. Absolutely. And provide no space, no gap in time for transition of care for mom. I mean, because that's usually the biggest concern, right? Like if I have a heart attack and I'm at the hospital, like, oh my gosh, I do this every day. I pay the bills. I make sure she has a meal, that can be really scary. So a tool that really helps in that situation is the Revocable Living Trust, just from the fact that you can do the work and fund it and set up your next trustee to step right in.
Yep.
I think that's really great.
I like that. No gap in coverage.
Yep.
Which leads to the next person. What if we're not talking about disabled spouse, but a disabled beneficiary, child?
Sure. So sometimes, we know that you're going to have to probate in the way that you are setting up your will. So again, still just your option. But let's say I'm a single person, I have one child, and they're disabled. I will need to include in my estate plan, no matter what it is, a special needs trust so that there's a trustee that manages for my child who is still the beneficiary and complies with the right rules so my child doesn't lose benefits like Social Security, disability, Medicaid, all of those important things that is providing health coverage for my child.
Let me just stop you. Just to be fair, this is what Kristen means. Your child's getting benefits based on their current economic status / health middle condition. Mm-hmm. You pass away, they inherit. By receipt of that inheritance, the government will reevaluate your child's assets
and kick them off
of benefits. And that's what we're trying to prevent from happening.
Yes.
That there's ways your child can be protected basically from your own passing.
Yes. We have a whole other video on special needs trust you should check out if you find yourself in this situation. But for those families, sometimes using a revocable living trust is a good tool in the way that you set up the special needs trust for your child, because we know you're going to have to probate. So if all you have is a will, your executor will have to probate at your death, will fund the estate, and then fund the special needs trust that is a testamentary trust created in your will. So you know that you'd have to probate. The situation that Chris and I have seen so many times is that when you use the will as the option here, you will mess up, and I'm sorry to say that, but you will mess up and you will list that disabled child as a direct beneficiary on a bank account, on a life insurance, on an IRA. So the benefit of the trust is that you move it all in there during your lifetime. That takes away that beneficiary because the trust terms control. When the trust owns it, the terms of the trust take over, and there is no longer a joint owner or a beneficiary where you can mess up and list your disabled child, because I promise you that you have and you will, just because if you're setting up life insurance, they say, who do you want to be the beneficiary? Well, I want my child to be the beneficiary. Correct. But legally, you need your child through a special needs trust to be the beneficiary, so you have to list it correctly. So a lot of times, this is a good tool to prevent you from making a mistake that nobody will realize until you've passed away.
Yep. Said often. Yep.
Yeah.
Okay. When does it make sense to have a trust?
Yeah, so I would say the things we've talked about so far are just, here's some, pros of having a revocable living trust. Still up to you whether you want to do a will that gets probated or use a trust. I think Chris said this earlier, but it really is about who does the work and when. With a will, you sign it and forget about it. Your executor does all the work. With the trust, you have to set it up and totally fund it during your lifetime for it to be helpful. So it's more work for you, less work for them. But there are some times where we identify to somebody, hey, this is a time where you might really want to think about a trust. If you don't have any of these situations, we just kind of put it out as personal preference and you decide. But there are some specific times when it really makes sense to have a trust, honestly, just to save you money for the most part.
Right.
But one of those is out-of-state property.
Yep.
So let's say that I reside here in Longview, my residence is here, but I have some, what do I own? I don't know, some mineral interests in Arkansas or a, lake house in Arkansas. When I die, so if I choose option one and what I have is a will and powers of attorney, when I die, my will has to be probated in the county where I was residing at the time of death. So even if it wasn't necessary to probate my will here, I will have to probate it, or my executor will have to probate it here in Gray County, and then take it and probate it in Arkansas. A probate in Texas does not transition title to property that is out of state. So if I've chosen that as my plan, I've chosen to have a will and 2 probates, because you'll have to probate in every state that you own real property. So sometimes people just don't think about this, right? So I own my home here, maybe I have a timeshare in Florida. Well, guess what? That's a probate in Texas and in Florida.
We see them all the time. We get phone calls from out-of-state attorneys saying, hey, we need your help because so-and-so died in New York, New Jersey, Florida, wherever it may be. They happen to own property in Texas. I guess we need to do an ancillary probate of a foreign will. And I'm sure it works in reverse for all those states as well. If you would like to cut out a bunch of attorneys in different states, think a trust that will allow those assets to pass outside the probate process.
Yeah, and no offense intended or taken.
Yeah, no, we're happy to help. But you can eliminate some of the attorneys if you do a trust, if you have properties in multiple states.
Yes, so that is a time where if I hear people say they have out-of-state property, I go, oh, well, I don't want to push you, but this is a time where you really need to understand what's about to happen.
Yep.
Yep. And so for financial advisors, CPAs, or other people watching as well, this is, I think, an opportunity for you to help identify that with people. I have some pretty savvy advisors that will now see clients and identify that for them and send them to me. That's really proactive, and I love it.
Yeah, they're like, well, we handled the bank accounts, investments,
right,
but what about all this property? And
right,
that will not, obviously work like a payable on death beneficiary.
Yes, exactly right. Exactly right. So another time when we just want to point out, so I am trying my best to tell people when they choose option one with a will, okay, you're going to have the will, but then you're also going to have to probate, right? Like that is just, you are accepting that as the will is my plan. I am planning for my kids to probate because that's, how things are going to transition. So if we know that you're going to have to probate to transition title to an asset, sometimes that makes sense then to set up the revocable living trust, and I think blended families are a good example.
Absolutely.
You want to talk about that a little bit?
Sure. Yeah. Blended families in Texas. What we are saying is that one of you, usually the deceased spouse we're worried about, has children from before marriage. Remember, in Texas, without a will, we know that when our spouse passes away and they have a child from before marriage, their half of the community property will pass to their kids. So if we have bought a house together, one half of that house is owned by their kids. One half of the vehicles. These things are problematic if that is not your intent. Yeah. If I've been married to my spouse for 35 years and I just happen to have a 38-year-old son, then my 35-year-old spouse, 35-year marriage to my spouse, who I think is getting everything, would not unless I've taken a step. One step, very important, is to make sure that there's a will. And if there's a will, it is probated. A will is not helpful unless it's also probated.
Right.
So sometimes we'll tell our blended families as a recommendation, listen, you know as a surviving spouse, you will have to probate. You will have to go through that process. You will have to make an inventory. You will have to go to court. You'll have to follow the notice provisions. One way to streamline that process is to do a revocable trust. A revocable trust, so long as it's funded, will allow that surviving spouse to transfer assets without the input of those children, of those stepkids, which at time of death, people have a hard time coping with your death. And I've seen some really great folks do and say things that they regret immensely, but at the time it creates a lot of chaos, angst, and frustration.
Yeah.
A revocable trust will streamline that process to remove potential problems in a blended family situation.
Yeah, absolutely. And if I'm surviving spouse, obviously I want that. But I also like to point out that it's probably a financial benefit as well. Yeah. So if I'm a blended family, and so many of them, if they've been married for a couple of decades, will say, well, we want it all to go to spouse, and then we want it to go equally amongst all of our kids, right? Mm-hmm. We consider them all kids. Great. Mm-hmm. Well, that means you're paying for the wills, you're paying for the first probate, you're paying for the second probate, and now you've spent more money than you would have if you did the trust. Right. So sometimes people, I think, get kind of a sticker shock. Oh, I don't want to set up a trust. It's not worth it. Well, at the end of the day, you know, if you know you're going to have to probate at all those times, it does actually save you money in the long run. Also, I want to point out here with blended families or with anybody, choosing to use a revocable living trust does not change the character of your property. So if I have an inherited farm that I put into my joint trust with my husband, if we later divorce, still my separate property, I still take it in the divorce. Community property retains its characteristics, separate property the same. So you've not, changed anything about Texas community and separate property laws here. If something, went bad and you got divorced or entered into a postmarital agreement or any of those kind of things, the character of your property has not changed by putting it in the trust.
Yep, absolutely. Blended family is definitely something to consider. Okay, another folks who come out on top on these trusts is also the kids.
Absolutely.
I know when I see a lot of kids, they come in, they're like, mom or dad passed away 2 weeks ago. We're kind of in shock. We'll give you this after death guide, kind of walk you through things you need to do. And a lot of times the kids start asking me questions. Well, hey, Chris, do you know what investments they have? Do you know where things are held? Do you know basically where all the bones are? And we don't necessarily know that stuff. It's not easy for us to have or know. There's no central computer that tells us everything. Sometimes my advice to the kids is monitor the mail for the next year, next 6 months, just trying to go through to see what actually shows up. So when you are doing this kind of revocable trust, you are laying it out, so long as you fund it correctly, on a silver platter for the kids. You're making their lives much easier during a time of great stress.
Yeah, I would honestly say the number one reason that I have clients choose the trust is simply they want to make it easier for their kids. Yeah. For whatever reason. They are, at the age where they're looking at retirement and they just want to get it set up, and they are happy to do the additional work that I've told them will be their funding homework. They are glad to do it. They just want to make it easier for their kids. Maybe because their kids live out of town, maybe because their kids live in town and they're going to be their caregivers.
Got their own busy lives.
Yes. Maybe their kids have 5 grandkids, yes. So I would say, honestly, despite all of these other good reasons, that just making it easier for their children and their successor trustees is the number one reason that people decide to do it. Yep. But we do need to talk about what goes into the trust real quick.
Yep.
So
seen some beautiful trusts.
Absolutely.
Beautiful trusts that
absolutely
didn't do anything, right?
Yes, there have in years past been scamish type deals that would sell someone a trust but not give them any information or help them fund it. Well, that is not a useful tool. So if you went to a seminar at the Golden Corral and somebody sold you a trust, but they live in Dallas, that is probably not a good estate planning tool for you, and you need to get that reviewed.
Yeah, I've seen it a bunch of times. People come with these huge binders their parents did. It's very nice. It appears to be a revocable trust. It looks like a revocable trust. Things are looking good. And then I ask the question of, okay, what does the trust own? What do we own? And then they all kind of stare at me with blank eyes. And I said, And then we'll start looking at the deed records. And I'll say, well, here's their home, but it's in their individual name, not in the name of the trust. Or where's the bank account? Can you bring me a statement? And there's a statement in their individual names, but not in the name of the trust.
Yeah.
If the trust doesn't own it, then the trust doesn't control it, which defeats the purpose of the trust.
Yeah. If you've listened to this and thought, I want to do an RLT, let me be clear. You cannot do this on your own. Number one, this is not a tool that you can accomplish on your own, period. I don't care what you find on the internet. You cannot do it. You will mess it up. Two, you need to find a reputable attorney in your area, living in your town, that you may run into at the grocery store and see again, to do this for you, to help you through it. This is not something that you do on the cheap, that you find somewhere online, or you do on your own. This is a not hard, but I would say more sophisticated tool than creating a will online. You need to do this correctly. You need to fund this correctly. So what assets, Chris, would I put into a trust if I were to set one up for me and my family?
So the first one I'm always looking for is the home. Usually it's the biggest asset. It's usually the most important. I want to know, is that home in the trust? It should be. Right? If we have a home and it's paid for, or, this should be in the trust. I should be able to go to the appraisal district. And I should assume it's in the trust. I should follow the appraisal district deed number over to the county clerk's office, and I have a deed that says that we as the grantors have given it to ourselves as trustees of our own trust.
Does this mess up my property taxes or my homestead?
Does not mess up your property taxes or your homestead. It's still your home. Same property exemptions. All that applies, but it is now controlled by you through the trust.
Okay.
So number one would be the home. Other easy things. Checking account, savings accounts, those should be owned by the trust. You should go to the bank, have a nice conversation, and change the ownership over to the trust. CDs, money market accounts, all should be owned by the trust. What about more complicated investments like IRAs?
Yeah, so the trust can and should own all non-qualified accounts. Any qualified accounts, which is, I use that term, I mean, I put it in while I was working, and at age 73 now, I'm going to have a required minimum distribution, and I've got to pull it back out. An individual has to own that account. It cannot be owned by a trust. It cannot and should not be moved into a trust. It's going to be owned by you as an individual, and you would need to talk to the attorney that is helping you to determine how you're going to list the beneficiaries, because that may be different. It may include the trust. It may not, but you want to specifically get the answer to that. But pretty much everything else you own is going to move into the trust. Your house, if you own any other land in any other state or here in Texas, if you own any mineral interest, that should go into the trust. Your personal property should be assigned to the trust. Your general everyday checking, savings, money market, CDs, anything that you have at any bank that is a cash account should be put into the trust. If you have a financial advisor and you have a cash account, or a transfer on death account, or an investment account, if it's non-qualified, it should be retitled into the trust. With a revocable living trust, do I have to get a new tax ID number or change anything? What does this mean for ongoing obligations?
Yep, those things do not change. When you are setting up this type of trust, you are, while the trust owns it, you are the trust, right? You're not, this is a bucket. It's a tool to gather assets and disperse, okay? There's other types of trusts that do different things. That is not this type of trust. This type of trust is for making it easier for estate planning for the next generation. That's the purpose of it. Gather assets and pour them out where they're supposed to go. So when it comes to your tax burden, your liabilities, all those remain the same. You are still responsible.
Yeah, as far as the IRS is concerned, it's still all your stuff. You report all the income like you always have, and you get no new tax ID number. It's still just your social. So hopefully, not every bank will do this, but hopefully that means that transitioning it in accounts will not mean closing and opening new accounts, but that will actually be up to your bank, not to us.
Yeah, every institution has their own rules. You just have to play their games.
Yes, correct. Is there anything else you'd like to say in closing?
No, other than, I guess I would say this. When you are setting up these kinds of plans with powers of attorney and then following up with the trust, oftentimes you're doing this for the next generation, right? I don't have people come in here setting revocable trust for themselves. They're doing it for the next generation. I did power of attorneys for myself. I set up the trust most likely for the next generation. So what I would do is inform the next generation of the plan. hey kids, listen, I've thought highly enough of you to do this planning. So here's where my original document is. Here's where you can find the stuff. I've seen some really great plans and some kids who were just clueless. Maybe they were younger when it was set up. I get it. But if you can, you should have a serious conversation with them, because you going to do all this planning doesn't help you if the kids drop the ball.
Yeah.
So.
Yeah, very true. Very true. But anyway, so a revocable living trust may be a good tool for you. This hopefully is some information that might allow you to make some decisions about that. But if you choose to use it, don't do it by yourself. Please contact us. We're glad to help, or find a reputable attorney in your community that can help you with it, and get your estate affairs in order.
Yeah.
So we'll see you next time.